Crikey, I'm a bit croaky there. Just finished my tea. So, thanks, Liz. After one of the last webinars, I was asked to talk about disability discrimination. It's something that we've spoken about before, but I think it's a bit topical nowadays. As you know, most of the employment tribunal claims as were, so the hundreds and hundreds and hundreds of them are dropping away. But what we tend to be seeing is an increase in the number of claims that are progressing on the grounds of disability. Certainly I am. I don't think that's a statistic. Maybe it's because they're worth more money, so discrimination claims have unlimited compensation as a potential. So there you go. Anyway, so we've been asked to talk about disability discrimination today. Disability is a protected characteristic under the Equality Act 2010. So I hear a lot of people they still use the phrase, I think I'm protected under the DDA or the Disability Discrimination Act. Well, that's now all encompassed under the Equality Act, which is a piece of legislation that takes all the discrimination legislation together. So if you're ever stuck or if you ever want to have a look at the legislation, I recommend that you do because from my experience of being in tribunal, the judge wants to know 9 times out of 10, first of all, is somebody a disabled person? Secondly, how have they been discriminated against? So firstly then, looking at what is a disability, it's important for you to know and spot a disability because you can be vicariously responsible for the acts of your employees or workers, for example. So what that means is if you've got an employee who's acting inappropriately, the individual who is taking the brunt of that behaviour won't be bringing an action 9 times out of 10 against a particular employee because they won't have as deeper pockets as you. They will come to the employer and say you're responsible for the acts of that worker. And you need to be in a position where you can show that you took all reasonable steps to avoid that happening, for example, in training and making your staff aware of the legislation throughout your policies, maybe updating once a year. I do that for clients, go in and sit with all the line managers once a year and, read them the Riot Act. So first of all then, they need to be able to spot what is a disability. So that's defined. So it's got to be a physical or mental impairment, and the impairment must have a substantial adverse effect, and the effect is on normal day-to-day activities. So if you've got somebody who's a concert pianist, obviously that's not a normal day-to-day activity, but things like shopping, washing, cooking, that kind of thing, things that we do on a day-to-day basis. It's got to be substantial as the effect, so it's not a minor effect, but it doesn't take into consideration the effect of any treatments, so without the treatments. And it's got to be long-term. Now, this is one of the issues that I have often been asked about, in the sense that most people say, well, it's not been long-term. I've only known that my employer has been stressed or depressed for 3 months, for example. And that might well be the case, but that doesn't necessarily mean that the issue isn't long-term. So it's whether it's lasted 12 months or is likely to last 12 months. So in order to be able to be in a position to assess whether somebody is disabled, then obviously the best way forward is to get some kind of professional opinion if you have any doubts whatsoever, and ask a list of relevant questions, including would you consider this person disabled for the purposes of the Equality Act, if necessary. But normally what we would do is we have a letter which we help our clients with that sets out questions in a particular way and relates it back to the job role of that individual and the effects that we know of to date. So just beware if you do get any issues of ill health, any medical certificates that indicate maybe stress, anxiety. Don't think, well, that doesn't say depression, so that's not a disability. Just have your ears pricked up about it, have a chat with the individual, and if necessary, get medical reports before taking action. Now, there are some things that aren't covered by the Equality Act. So some exceptions, for example, if you employed somebody who was an arsonist, or somebody who was an exhibitionist, or an alcoholic, for example, those things aren't covered in the by the definition of disability. But what I would say to you is just beware of related symptoms. So one of the most common ones that we have is alcoholism. And I have had drug abuse before, but I'll stick with the alcoholism for now. So you might have an employee who hits the drink, becomes morose, has related health conditions. On the face of it, the alcoholism isn't a disability. However, the related symptoms, and often with alcoholism it's depression, anxiety, other issues, liver-related issues, kidney, that might be a disability. So don't just write it off if you think it's an excluded condition. Um, just beware of it. That being said, obviously, just use your common sense. I did have an interesting question at the College of Law the other week about tattoos. Um, Having a tattoo is not a disability, and I've had quite a few questions about employing people with visible tattoos, actually, and whether that's discriminatory, i.e., I can't employ you because you've got a tattoo, and scarring, because some kinds of serious scarring can be a disability. And one of the students mentioned to me about Professor Green, who I didn't really know anything about. You might know, I don't know. You're all nodding probably at your desk thinking, we know that, she's really old-fashioned. But apparently he's got a huge scar and he's had it tattooed over, so that provoked a great debate about whether actually he would be classed as disabled, which I suspect not, but at least it was an interesting 10 minutes. Anyway, Liz has gone on to the slide about legislation. Now remember, the discrimination legislation covers employees, contract workers, partners and office holders, and it's a day one right. So it's a day one right not to be discriminated against. It applies to recruitment, terms and conditions, promotions, transfers, dismissal and training. So from the date that you interview, as I said previously, unfortunately in the discrimination world it's unlimited compensation, whereas basic unfair and constructive dismissal claims do have a cap. And so it's very important to identify it at an early stage and be open about it. What I would say to you is that the key to defending any of these claims is a clear paper trail. Um, the he said, she said approach often doesn't work. It's very unpredictable. So if you do have any issues, try and note everything down, conversations, meetings with staff in relation to sickness particularly. And remember that to bring a claim for discrimination, the individual doesn't have to leave employment, so they can present a claim based on the employer's conduct but still be sitting there. And I'll come on to that later, so wouldn't necessarily have to leave. I've got a question here, but my glasses aren't suiting me right. So what's the best way to note and record these meetings? Well, in my opinion, if you make a contemporaneous note of everything that happens and put it on the personnel file, or if you do have precedents in place, sort of return to work meetings, and you apply those consistently, then it doesn't even have to be as formal as sending a copy to the individual, as long as you have a note that it's, for example, the 13th of July, you had a meeting with the employee on return, this is what they said, this is the agreed steps forward, and you can demonstrate that you acted reasonably and you took all reasonable steps to address any potential issues. If at the tribunal stage, of course, you can produce an enormous amount of notes that show that you acted reasonably, and in fact, for example, an employee might never have mentioned that they'd been ill to give you any indication that there was an issue on disability. Then for some of the claims you may be able to present a reasonably robust defence. I love large bundles, and there's a joke in there somewhere. So if I ever defend a claim on behalf of a client, it's absolutely fantastic if they can present me with a really thick personnel file and a lot of information in there to get my defence off the ground at an early stage. So I hope that helps, Sarah. Okay, so the other issue with discrimination claims, just on the legislation point, is timing of a claim. In relation to timings of any potential claims, as you'll all know, with unfair dismissal, you have 3 months less a day from the date of dismissal or the constructive dismissal, but with discrimination you've got 3 months from the date of the act of discrimination or the last act of discrimination if there's a series of events. So always look at timings if you are ever presented with a claim, because that might be relevant. Okay, so moving on then. The types of discrimination we're going to look at I've placed on that slide, but I'm conscious I'm waffling, so we'll go to the next slide and look straight away at direct discrimination. So what I've done here is I've just presented you with a summary of what the legislation says in relation to each one. I'm going to try and give you an example. So we're looking at direct discrimination under Section 13 of the Equality Act. I have a real issue with this because maybe it's just me, but I think this is a really hard claim to present. Basically, what the claimant has to prove is that because of a disability, they've been treated less favourably than you as an employer or the individual who's the respondent, if that's the case, would treat other people. So this wording in the Equality Act replaced the previous wording, which was that on the grounds of disability you'd been treated less favourably. It doesn't really make that big a difference in my world, because what we really look at is we need a real or a hypothetical comparator if you bring in a direct discrimination claim whose circumstances are not materially different to that of the claimant's. And what you say is, because of my disability, I've been treated in a way that another person who's my comparator would not have been treated. And trying to get a comparator, sometimes it's really easy. So in a sex discrimination claim, the comparator obviously normally is a man. But in disability discrimination, it's quite difficult. You have to be clear about your comparator, and I'd say take specialist advice. I'm not going to labour the point too long on this, but I think direct discrimination claims are hard to get home on because it's very rare that you'll have an individual who will say, I am dismissing you because you are depressed, or I am dismissing you because you've got one arm, or because you're blind. It has happened, don't get me wrong. Also, an employee can say, I believe that that's what's happened, but it's very, very hard to prove. I have only ever had one case, and I've been doing this 14 years, where an employer actually said to an employee in a meeting, which was recorded covertly, yes, I do understand that you're depressed. I think that will affect your work going forward. One of my relatives suffers with a depressive illness, and then the next day wrote them a letter saying they were dismissed on the grounds of redundancy, but for no other reason. Now, that case was hard fought. In that case, the individual had only actually been working with the company for a period of about 3 months, but was successful in a claim because the tribunal did believe that because of the disability, she had been treated less favourably, and in fact, that less favourable treatment was her dismissal. So in that case, again, unlimited damages. A bit of a nightmare really for the employer, but then again, it's a warning, isn't it? Always assume that you're being recorded is my warning to you on that one. Okay, so what I would say for you for direct discrimination is you've got to say it's because of the disability, so it's not for a reason relating to it. That's a different head of claim. Also note on that you can be discriminatory towards an individual even if it turns out that they're not disabled. So if you have an employee who says to another, makes an assumption about another employee that they're disabled and treats them less favourably because of that, even in the event that they're not disabled, that can still be a discriminatory act. So that's perception, discrimination by perception. And you can also have associative discrimination. So the best example of that I can give you is if an employee is treated less favourably because, for example, they have a dependent who is disabled, so a son or a daughter. So just watch out for that as well. Okay, so that's a sort of brief overview of direct. As I say, I've not had very many wins on that, particularly when I was acting for claimants some time ago. So we'll move on now to indirect. So indirect, so direct is obviously what it says on the tin really, because of, but with indirect, there's this long-winded definition, and people will try to, I always think lawyers throw these terms around, it's a PCP, what's your PCP, and it all becomes a bit aggressive. Well, basically, what you've got to show for indirect discrimination if you're a claimant is that there's a provision, criterion, or practice, and that's your PCP, that the claimant had a disability, that the criteria or practice applied to everybody, but it puts somebody with the claimant's disability at a particular disadvantage, and you'd have to show what that disadvantage is. You also then have to go on to show not just that it puts them as a group at a disadvantage, so you have to show a group disadvantage for people with the claimant's disability, but also to demonstrate that the claimant is also put at that disadvantage. So what is the disadvantage, and was the claimant disadvantaged? Now, the example I could give you here is, for example, say you've got I don't know, I can't even think of one off the top of my head now. Say you've got a practice of having your away days, and they're all super active away days, like, monkeying around or whatever that place is called in North Yorkshire. What's it called, Liz? Go Ape, that's it. So say you always have your away days and your team meetings at Go Ape, and you've somebody who is physically impaired. On the face of it, you're applying that practice of going on your away days to Go Ape to everybody in the firm. So you're not saying we're doing it because you're disabled or anything, you're saying that's what we do on our away days. But if you've got somebody who is physically impaired, and it puts people who are physically impaired at a disadvantage and puts that particular person at a disadvantage in the fact that they can't go to the away days and the training sessions, because this applies to provision of training and interviews, etc., then that might be a form of indirect discrimination. Now, that's just a vague example off the top of my head, don't quote it, but it's a bit similar to sex discrimination on the height restrictions. So, you have to be 5 foot, 6'1" and over, for example, and indirectly that puts women as a group at a disadvantage over men. Because obviously more men than women have a height issue. So it's that sort of principle. Again, indirect discrimination in disability world it's not one of my most popular claims. It is for defending, because if I see that, I think, well, I might get away with this. I think it's a hard claim to present and to win. But if I was a claimant, it wouldn't be my favourite claim to bring. So moving on then, and on that basis, the most popular claim that I see coming from claimants now, and the one that really has the most teeth for most of them, is the Section 15 claim, which is discrimination arising from disability. So this is where the claimant is treated unfavourably because of something arising in consequence of their disability, and the respondent can't objectively justify the treatment. So objective justification is, can you show that your treatment of the individual is a proportionate means of achieving a legitimate aim? In other words, have you got a decent excuse for what you've done? Without going into any more detail on that, going back to the arising from, the employer must know or should reasonably have acknowledged that the person is a disabled person or of the disability upon which the claimant relies in any claim. And if the claimant can show that they have been treated unfavourably because of something that's related to their disability, so in consequence of the disability, then they might succeed here. So, although that sounds like gobbledygook, let me put it into some kind of example for you. So the examples I've come across are mostly sickness absence. So people who have been dismissed because of a large amount of sickness absence, and they say, well, that's related to my disability because my disability means I have to have 40 days off a year, or I'm regularly ill a particular time in the month, or when treatment is starting or ending. And another example I've had is where somebody has at times lost their temper in a way that they would not normally have done because of pain at particular times in the day, and being dismissed ostensibly on the grounds of conduct, but in reality they've said, well, actually this behaviour is arising from my pain, which is about my disability. I've also had an individual who has been dismissed for taking time off for medical appointments, and that's one of the other common ones where they say, well, the time off medical appointments obviously arises and is in consequence of my disability. So there's just a few examples. If the person is treated unfavourably because of this, then they might have a claim. And I just want you to highlight the word unfavourably there, because it's not less favourably. There's no need for a comparator in this claim. So in the other claims, you have to show that vis-a-vis somebody else, in the direct, for example, vis-a-vis someone else, you've been treated less favourably. But in arising from, all you have to show is that you've been treated unfavourably, and that, it wasn't justified. Other examples, I'm just thinking now if I could give you any other ones that might be relevant to you all. Other examples I've had are people who have been dismissed because their typing has slowed down, which has been related to a serious arthritic condition. Somebody who needed the toilet more often because they had a disability that made them need the toilet more often, and it wasn't very well thought through as a dismissal by the respondent, and they had an arising from claim. I've also had circumstances where, because of certain mental health conditions, an individual has needed to work in a quiet working environment or have specialist equipment, and that wouldn't necessarily, again, if there was any detriment or unfavourable treatment because of that, there could be a claim there. I've got some questions here. How would arising from relate to a performance problem based on their disability, for example, dyslexia? I'll come back on that. Okay, so I'll come back on some of these questions because I'll rattle through the slides first, and then I'll come back to them if that's okay. but yes, capability is a big issue when we're looking at disability. Um, okay, so just moving on from that then, the other requirement in relation to disability discrimination is the requirement to make reasonable adjustments. So there's a duty under Section 20 to make reasonable adjustments to premises or working practices to help disabled job applicants and employees. And that, I think the sound's gone somewhere. We're not sure. The reasonable adjustments is exactly what it says on the tin. The adjustments have got to be reasonable. Thanks, Sylvia. Sorry, Eloise, I'm not sure what's happening there. So you wouldn't have to go as far, it depends what's reasonable in all the circumstances. There's normally a full assessment, but the adjustments that you might see most commonly asked for are changes to meeting venues, times of meetings, times of conference calls. So, for example, I've had to deal with individuals at my clients who, for one reason or another, and it might be related back to the toilet issues or stress, medication issues or treatment issues, where they can work and they can work well, but they can't take conference calls until 10 o'clock on a morning. So an adjustment might be that we make any meetings with, as for example, a partner in the States or an overseas subsidiary at a certain time to suit somebody's disability, and that would be classed as reasonable. I've done that on many of occasions. The other most common situation is equipment, the provision of specialist equipment. There's so many things you can get nowadays. Just going back to the dyslexia question, you can have screen tints. There's lots of software which is relatively inexpensive. I've been working with a client a couple of years ago where we did actually think that a dyslexic employee was incapable of carrying out a role, but when we discussed this with a specialist and introduced some equipment, gave them about 3 or 4 months to get to grips with it, they've ended up being one of the top performers now at the company. So I think, think hard about it before you write it off. But obviously, you don't have to spend a ridiculous amount of money for it. The example is installing a brand new lift for one person, for example, but you still do be careful there. Working hours obviously are adjusted on a regular basis to suit people and their treatment schedules, etc. And sometimes flexible working can help. Okay, moving on then to, hang on, stress-related illness directly affected their ability to take time off to attend an intensive. Right, what I'll do is I'll deal with them at the end. Yeah, I will. I'll deal with all the questions at the end, so just hang on for me, and then, yeah, we'll get through the slides, and then whoever needs to log off can log off. So harassment then. So this is another type of claim under the Equality Act, but also be aware that there is a civil action of harassment as well. I've not really seen many of these claims, civil actions of harassment, but I've seen them a couple of times, and they just bump up the costs if they go forward. I won't go into those here because that's not my speciality, but under the Equality Act, the Section 26, there's also can be presented a claim for harassment, and an individual can present a claim for harassment if they can show unwanted conduct which is related to a disability that has the purpose or effect of violating the dignity or of creating an intimidating, hostile, degrading, humiliating or offensive environment for them. Okay, just going over to the next slide, and I'll just finish that off here. All that is judged by the tribunal, taking into account the claimant's perception of what happened and all the circumstances of the case, and also whether it's reasonable for the conduct to have had that effect. So it's a bit of a balancing act by the tribunal. If somebody is super hypersensitive, it might not have been reasonable for them to have taken some form of conduct as violating their dignity, for example. So it has to be more than minor. But it can take any kind of guise. So one of the key examples in it, and this was an actual case, when one individual during an interview process in earshot of the particular candidate called him doolally. I think he's a bit doolally, knowing that he disclosed on his former a mental health issue. I mean, that's probably one of the most obvious ones. He said, well, he said it in front of a number of other people. It was an internal interview process, and actually it did it violated my dignity in itself, that comment, and created an offensive environment for me to work in. Also, be clear under this that it doesn't have to be based on the individual's disability. So again, going back to the associative discrimination point that I mentioned earlier on, it may be that an employee has a disabled son, daughter, relative, and they can bring a claim of harassment based on that particular person's disability rather than their own, if the behaviours are unwanted, related to disability. It doesn't say related to the individual's disability, and if it had the effect of violating their dignity, etc. So go through that. In relation to harassment claims generally in the tribunals, what you tend to find is that if a claim is progressing, the individual is asked to specify which particular incidences and comments and circumstances they say amounted to acts of harassment, and they tend to have to list those. The other thing I would go back to here is that, remember, you've only got a 3-month deadline if you're a claimant from the date of the act to bring a claim. So what you tend to find is that most claimants commence claims and then try and link a series of acts. So it's not uncommon for claimants to say, I've been harassed, and I was harassed, from January this year. On January the 10th, he said this. On February the 2nd, he said that, and to try and tie it into a link or a series of actions. So if you have staff, or if you are aware of any of your employees who may be acting inappropriately, on any level really, again, this is where your training comes in, doesn't it? Because not only can they be held liable personally, but the company can be held liable, and to my mind, it would be better if they were all made aware regularly of the provisions of the Equality Act and the different types of harassment, particularly in relation to disability. So there you go. Now, the last one here, you see why I'm not answering your questions, because I'm trying to finish this off quite quickly. The last one here is victimization. This is another form of discrimination. And this, in the briefest of examples, is where the employer puts an employee to a detriment because he or she has, that's a typo there, has done or intends to do or is suspected of doing, so not don't, I mean say done, a protected act. God, the typos are appalling, and I'm sorry, I must have been tired. So, for example, if you had an employee who was had raised a grievance and had said about a manager, I have been treated badly, and I think this person has treated me badly because I have depression, and this person has a lack of understanding of depression. And I think I have been discriminated against, or if they've intimated that they feel they've been treated less favourably, etc. If as a result of them intending to bring an act under the Equality Act, or to raise a grievance about discrimination, or to present a claim, they are subject to detriments. So, for example, they might then go for an interview internally for a promotion and not get it. And they might say, well, I think I didn't get that promotion because I had accused Mr. X of discriminating against me, or he thought I was going to do so because I had raised a grievance. Then that would be a detriment, and potentially that act of not promoting the person could be an act of victimization. That's the best way I can think of to describe that. That's quite a common area. So if you do have anybody who's making noises through a union or in writing or grievance, just be careful about how you treat them. Additionally as well, this tends to trip employers up when employees do bring a claim. So for example, failing to make reasonable adjustments. I want you to buy me X, Y and Z and you haven't, I'm raising a grievance. That's fine, but they're not leaving to raise that grievance. They wouldn't even have to leave your employment to bring a claim for you failing to make reasonable adjustments. And then they could be sat at their desk. Now, to me, that's dangerous if you've not educated your staff properly, because you'll always get one, or 9 times out of 10 you get one, who starts becoming aggrieved and thinks that that person is a trouble causer, or is, being prioritised because of a disability. And it only takes a couple of comments or something to be treated differently for then them to be able to add on an act of victimisation. So the most obvious one I said is lack of promotion, but it could be anything really, anything that's a detriment. So not being invited on nights out, not being invited into meetings, anything that means you're treating them differently and worse than you would normally because of the Equality Act proceedings. And you don't really want that that kind of a claim bringing either. Remember here again, there's no comparator needed or anything. All they have to show is that they've been put to a detriment. Right, so that's a whistle-stop tour, which I think I did my 30 minutes there, didn't I? Whew, wow. Right, okay, so that's the whistle-stop tour of it. Now I just need to pull the screen closer to me because I'm obviously too old. Can't see. So there's a few questions here. So the first one is, how would arising from relate to a performance problem based on their disability, e.g. dyslexia? Well, that could be arising from, because if somebody is, for example, and I've had this recently actually, I say in real life, but you get my gist. Like I said, where an employee was not performing properly, they were not completing the tasks as quickly as their co-workers. And they said it was because they were dyslexic. My client said, well, I don't think you're performing properly, you need to leave. I said, I think you need to establish whether there's something you can do to fix this. Otherwise, that person may say, well, I'm not performing fast enough because I'm dyslexic and I need extra time to read. And the extra time is in consequence of my disability. So, as I say, we did go through a process there. We actually had 2 meetings with the individual who was absolutely elated. It transpires they'd been dismissed already from another employer on the same grounds but never mentioned it. I think genuinely thought they'd never hold down a long-term job again. And now, like I say, one of the best performers. It didn't cost a lot. There was a bit of upfront cost in an assessment and some specialist equipment, but by no means it's been totally outweighed now by the benefits to the company. And actually, I think that person will now be there for a very long time because they've demonstrated a reasonably good understanding of the situation. So yes, that could be arising from. Kate says, how is it best to deal with somebody who has had a high absence record relating to disability and it is raising questions on their capability to do the role for which they're employed? Well, in relation to capability issues in relation to absence, then really what we say is what you need to do is have a proper absence policy and a capability policy that relates or is tailored to deal with people who are not capable of doing the job because of the sickness absences. Because there's 2 types of sickness absence, isn't there? There's the deliberate sickness absence and the intermittent, which are in no way related to a disability. But then there is also the sickness absences, which are directly related to disability, and you do need to be careful there. So you would have to show that you had tried to go through a procedure with that person, to talk to them about their absences, to make notes about what you can do to help them to be employed, to remain employed. A lot of other options, so can they do reduced hours? Would it be better if they had a reduced job role? Do they want to step into a different role? Explore all the options with that person before you take any serious steps to dismiss, because then you can also satisfy the criteria that you've tried to make reasonable adjustments for them in the workplace if they have a disability. So if you have a legal advisor in place, they should be able to help you with a policy, or if you have somewhere that you can obtain policies, there are policies out there which give you some guidance as to the meetings that you can have, what happens at each meeting and how it's best dealt with. So look for a good policy and take some good advice, Kate. Okay, so the next one is, if an employee has a stress-related illness such as PTSD, which affects their ability to do the job, and took time off to attend intensive treatment residential, how would you be expected, how, as the employer, would you be expected to wait for them to attempt to solve the problem if they continue to take sick leave, attend residentials and return with the same problem? How long, that's right. It's really difficult, is that? I mean, it's how long is a piece of string into it? It depends how reasonably you can demonstrate that you've acted in all the circumstances. I think in that case, you'd need to take pretty robust medical evidence. You'd have to get some specialist reports. And ultimately, if the individual is not capable of carrying out the role, then it is absolutely fine to dismiss as long as you've explored all the other options. So if you had, for example, been through the process for a significant period of time, the person is never at work, it transpires that as a result of a couple of medical reports, or even one medical report, that they probably never will return to that role, it may be at that point that you'll look to go through a process to dismiss on capability grounds. I mean, with disability, it doesn't. If you have a disabled employee, it doesn't mean to say you have to have the disabled employee forever if they are incapable of doing their job. It just means that you have to show that you have acted with a vigorous level of commitment to the employee before you dismiss, in a view to try to accommodate them. So I think it swings and roundabouts, and each case is based on its own facts. But I'd say get some medical evidence on that, because if they're not capable, they're not capable. And let's have a look. What is the obligation and expectation to protect employees from harassment from third-party customers, and what actions should we take if incidences occur? Oh, I've had this before, Megan. That's a bit of a blind side for me. Yeah, just I'll come back to you on that on email. Drop me an email about that, because it's going to take me off into another 10, 15 minutes. Drop me an email afterwards, and I'll send you the information on that direct if you like. And then finally, if somebody's on permanent health insurance, how long can they stay on there, and can you terminate while they're on PHI if they're never coming back to work as per medical reports? Well, crikey, Elizabeth, it depends on the facts is the answer. You'd have to check the terms of the PHI. It depends on the terms of the contract, so it depends what the contract for that particular individual says. There are contractual provisions often which dictate whether you can or you can't dismiss in those circumstances. And I would liaise with the insurer on that, because I have had cases in the past where the insurer, in light of the medical reports, takes a view and makes a payout directly to the employee vis-a-vis paying them out indefinitely on PHI. So it may be that your insurer might want to make a settlement payment to the employee if they're never returning, rather than carry on paying indefinitely, which might get you out of that. So speak to the PHI provider and see how you get on. Right. Yes, so just to say that obviously any of the advice that we give in these webinars is not insured, and in fact is not advice really. So if you do have any specific issues, then I'm sorry if I sound vague, but obviously I don't want to be exposed. Do drop me an email, and I can come back to you directly if necessary. But yeah, thanks for having us today. I'm sorry that we've overrun a bit, but I hope that you found the webinar useful, and I'd like to thank Liz for having me, and I'll pass you back to her to say goodbye. Enjoy the rest of your summer, guys, and hopefully we'll see you in September. The other thing I would say is please do link in with me, or follow us on the Twitter feed, because we like to know who you all are and keep in touch. We've got a bit of a community going here, haven't we, Liz? Same goes for Liz. Okay, I'll just pass you back over to Liz. Thank you.
Thanks, Marie. Brilliant. Lots of useful information there again. I'm sure everybody got some good stuff there. And as Marie said, she will come back to, if you want to email Marie directly, she will come back to you with those questions, and someone I just noticed with regards to the third-party harassment as well. Will do, Georgia. So that's fabulous. So really, we'll penultimate webinar. Next week we've got the 2010 event taking place and developing people using that model. It'd be great to see some of you back again for the final one for this before the summer. If not, I'd like to thank you all for attending and for some brilliant questions there, and we look forward to seeing you after the summer break, which will be on the 8th of October, and that's with Barbara Nixon. So I'll send you some details, as I said before. So thank you very, very much. And please let us know if there's anything else that we can do for you. Thank you.